Thank you, everybody. My name is Conn Maciel, and today we are speaking about employee privacy rights. Privacy rights have been an important topic for employers for a number of years, but in particularly just in the last year or so, we've seen a lot more states start to enact legislation that impacts how employers regulate and collect and disseminate employee private information. And so we're going to be talking a lot about that today, various areas where you are able to legally monitor your employees and other federal and state and local laws that may put some restrictions on that. My name is Conn Maciel. I am the founding partner of Conn Maciel Carey. I chair our labor and employment practice across the country. I represent employers, on all aspects of the employment relationship, both counseling employers on a myriad of issues, defending employers in litigation, and advising union and non-unionized employers on labor relations. I am joined with me by my colleague, Darius Rohani Shukla, and I'll have him introduce himself. Darius.
Hi, everyone. Good afternoon. My name is Darius Rohani Shukla. I'm an associate here at Conn Maciel Carey. And today, this topic is of particular interest to me because I'm a certified information privacy professional with the International Association of Privacy Professionals. So I really enjoy talking about this subject. I'm excited to share it with you. As well as that, I represent clients in all aspects of labor and employment law, restrictive covenants, wage and hour disputes, data privacy issues, and sort of your discrimination, harassment claims, and wage and hour complaints. So I'm excited to present this today.
Thanks, Darius. So I'm going to kick it off today to start about just generally opening it up to what is, employee monitoring. So, employee monitoring, employers can monitor using a variety of tools to surveil employees in their workplaces, including both where they're physically located, as well as what they're doing, their keystroke activity on their keyboards or other areas. Oftentimes, employers use employee monitoring to prevent internal theft, examine employee productivity, particularly right now in the era of a lot of hybrid and remote working. Employers are more interested in ensuring that employees are being productive when they're at home. And so we're seeing more people use that type of keystroke and other type of monitoring system. And then also just ensuring your company resources are being used appropriately. A variety of different software methods include to make sure that someone, when they clock in on time, when they clock out for breaks or lunch or meal periods, clock back in, and when they clock out for the day. We're seeing employers use video surveillance in common areas or at the entryways, badging software coming in and out when you exit, and the movement of employees within a facility. GPS systems. If you use a company car, you've got a driver, you've got employees that go to different locations, you can use GPS systems to track mileage, to track when they're online, when they're in the facility. And then recently, we're seeing a lot more employers start to use biometric technology. So this is either fingerprint scan or iris scans that you can log into the computer to maybe support your time and attendance software or other productivity issues. It's important, if you do have employee monitoring, that you have transparency and you provide notice and employees understand when they are going to be monitored and at certain circumstances need to provide some consent. So there's a lot of different sources of employee privacy rights that we're going to talk about today. The main one under federal law, there's not a lot of federal legislation right now on privacy, but the main law is the Electronic Communications Privacy Act of 1986. This law extended the federal wire prohibition on the unauthorized interception of electronic communications, even wire communications, oral communications, and what the ECPA did is it extended that to electronic communications like email. Although there's two main exceptions for purposes of the workplace. The first exception, which is known as the business purpose exception, allows employers to monitor employee communications if they can show that there's a legitimate business purpose for doing so. The second exception is known as the consent exception, and that allows employers to monitor communications as long as they have the consent of the employee to do that. And notably, it's not limited to just business communications. Employers are able, with the consent of their employees, to even monitor personal communications again, pending they have the requisite consent. So those two exceptions are where a lot of the monitoring falls for purposes of federal law. And it really does allow standing alone most types of the type of monitoring you would want to do in the workplace. The second type of that employees may see comes from common law. So there, privacy rights are implicated in a number of different ways. And whether an employee has privacy in the workplace, courts look at a variety of different factors. One is whether the employee had a reasonable expectation of privacy. The second is whether the employer intruded on that reasonable expectation of privacy, and if so, to what extent, and whether the employer had a legitimate business reason for its actions. So, following back to the business purpose exception of the Electronic Communications Privacy Act, always want to think about what monitoring, what's the business purpose for it, to ensure that you can document the legitimate business reason for the action. Importantly, employees do not have a reasonable expectation of privacy over company-owned property, over the equipment, over the computers, or other property that you may provide to your employees. We'll talk about this in a little bit furthermore with the state law issues, but think about other ways that employees use company-owned property, phones, computers. They may be able to access their personal data on the computers, their personal email account, or other personal areas. And so you also want to make sure, do they have an expectation of privacy potentially on that form of communication, even though it's on a company-owned computer. So beyond sort of the federal law and then common law protections, we really want to look at state laws. And it really varies state by state. As we're seeing, more states are starting to pass laws that protect employee privacy rights. So it's going to be important that when you're thinking about what you're doing in the workplace, not just check where you are headquartered, but where the employees are located and the state laws that may be implicated where those employees work. For example, here's just a couple of various state laws on workplace monitoring. I'm not in a position to cover all of the states, but I think that some of these are pretty interesting. Both New York and Connecticut require specific posting of any type of workplace monitoring. So you want to make sure that is done, in advance. For example, in New York, you have to notify employees at the time of hire, either in writing or electronically, and then that employee needs to acknowledge, and then similarly post the notice of the monitoring in a conspicuous place, probably where you would otherwise have your other workplace monitoring posters. Other, California, specifically says you can't conduct video or audio surveillance in specified areas of the workplace, such as restrooms or locker rooms. We're seeing that pretty similar. Connecticut has a similar law. That is not, a common area. Those are areas where employees would have a reasonable expectation of privacy because they're private. They're not, within really the employer's controlled area. And so, think through areas where you may be monitoring and whether it is considered, personal, private, whether it's a phone call, email, in-person conversations. Make sure you're looking at whether state law requires advance notice, consent, or acknowledgement before you do that. Talking about, as I mentioned, sort of access to personal online accounts or social media accounts. Generally, a lot of states have passed laws that restrict employers from asking about the employee's login information for their personal email accounts, including social media accounts. Here's a list of the states that have those restrictions. So it's my best practice not to have employees disclose that type of information to their employers. However, if there is a reason where you believe that you've got internal investigation into workplace misconduct or a work-related violation of the law, you can ask to get social media account information, so long as that is part of the investigation and the use of that access is limited for that legitimate business reason. Then we talk about sort of physical workplace privacy, whether an employee has an expectation of privacy in specific areas of the workplace is really case by case, but generally, it considered these factors, right? The characteristics of the location claimed by the employee to be private, a locker room, a cafeteria, a restroom, whether the employee's actual practices with respect to workplace searches. So here we are, a locker room. Do they have an expectation that they can search the lockers at any time? Do you have that in writing? Have you done it in the past? The stated practice with respect to workplace searches. What do you have in your employee handbook? Do you have a separate policy? And then the reason for the workplace search. Is there some type of cause or something about the investigation that leads you to believe that it's important for you to do a search? Mostly, as I said, common areas, even at a workplace desk or workplace office, generally employers have the right to search those areas, largely because that's a workplace that's been furnished by you, belongs to you. And courts generally find that employees don't have an expectation of privacy in that type of workplace. But as I said, other spaces, even possibly, a parked car in an office parking lot, would be dependent on whether an employee has a expectation of privacy there. So we get a lot of questions about medical privacy and when can an employer share medical information about an employee. And so I'm going to cover the various federal laws that come into play when we're talking about someone's health condition. So one of the first questions I often get, and employees often say, is, oh, you can't share this information. It's covered by HIPAA. HIPAA is a federal law that talks about protecting patient health information. But for the most employers on the call and our clients, HIPAA does not apply to private employers. HIPAA really only focuses on, certain types of covered entities. Those are health plans, healthcare clearinghouses, or healthcare providers. So if you're not a healthcare provider or a health plan or a clearinghouse, generally the information that you've been given by your employee is not covered by the privacy rule and does allow you to disclose and use that information for various business reasons. There's a second rule that talks about a security rule that applies to, in addition to health plans, but also sort of associate attendant companies, billing companies, maybe healthcare claim processors, sometimes lawyers if they have that information, accountants, various individuals that may have that. Usually there's a business association agreement with the healthcare plan in terms of how those types of entities protect that information. But again, those entities they're not collecting employee information. They're collecting patient information. So it's really outside the scope of the employer-employee relationship. And then the third rule is the breach notification rule, which requires, again, covered entities and their business associates to provide certain notice should there be a breach of unprotected health information. There may be other data protection laws and data breach laws that you may have to comply with if your employee's medical information is somehow breached, but it really falls outside of HIPAA. So oftentimes this may come into play, for example, if you require your employees to, pass a drug test, they go to a drug testing facility, that information's collected, that entity is collecting personal health information of the employee. That entity needs to protect that information under HIPAA because they're the ones that are collecting that information. But when that information is shared to you as the employer, either by the employee or otherwise, then that is no longer something that is governed by HIPAA, may be covered by a different law, but generally that is information that you can use and you can maintain, as an employment record. The second federal law that also often implicates employers with medical information is the Family Medical Leave Act, right? So the Family Medical Leave Act provides job protected leave for employees when they have a serious health condition that makes them unable to perform certain job functions. And when they have that serious health condition, it's generally unlawful for you to disclose that information that you've obtained from the employee who's applying or using FMLA. Often that's done in a copy of the certification from a doctor or healthcare professional. It doesn't necessarily have to be a doctor. It can be a medical healthcare provider. And that medical certification is going to is going to include information like the dates when the medical condition began, the duration of the medical condition, and some facts that are within the knowledge of that healthcare provider about the condition. And that's the information that often would be deemed confidential, private information of the employee. So what happens when you get that information? Can you ask the employee about it? Can you ask the employee's healthcare provider about more details? And the answer there is generally yes. You are able to get more information from the healthcare provider to either authenticate or clarify the medical certification. In doing that, it's important that you make sure who is the right person to inquire about that to that provider. You cannot have the direct supervisor contacting the healthcare provider. It really should be an HR professional. It could be if you have a third party that administers your FMLA leave. It could be another member of management, so long as it's not the direct supervisor, or it could be, another healthcare provider. And then if you get that certification, or if you're not getting good clarity from the healthcare provider, you can also request a second opinion if you doubt the validity of a medical certification. If there's inconsistent dates on the duration of the condition, or the facts of the condition don't really support the need for how long they're asking for time off or the intermittent leave request. So you are at your discretion and at your cost. You can ask and require, as a condition of certifying the FMLA leave, to have the employee be examined by a doctor of your own choosing. And then when you get that second opinion back, if the employee doesn't agree with it, the employee can ask for a third opinion. Again, that third opinion is at the employer's expense, and that third opinion is going to be final and binding on both parties as to whether the certification supports a serious health condition. I would say it's not often that employers will challenge the validity of a medical certification, but it can be done, and it certainly is a strategy to the extent that you feel you've got an employee who may be abusing the FMLA leave. So another federal law that talks about medical information, is the Americans with Disabilities Act. And under the ADA, there's various stages in which you can collect, ask about, or examine employees about their medical conditions. The first is in the application stage. And generally, here is the only time that you really should be asking an applicant to demonstrate how they should perform essential functions of their job. You can ask an applicant with an obvious disability, but besides that, you cannot be asking for any medical exams or any other medical inquiries during the application stage. You really have to wait on that until there's been a job offer. You can make a job offer conditional upon a medical exam, so long as you make sure all other applicants and all other entering employees for that job are subject to the same medical exam. And that you use those results, in compliance with the ADA. You're keeping them confidential. You're only using them to determine whether an employee can perform the essential functions of the job. And then once they're employed and they're working for you, generally the ADA does not allow you to require an employee to submit to an exam or ask questions unless that inquiry is related to the functions of their job and, again, consistent with business necessity. So it's important to understand when you can and when you cannot ask questions about someone's health condition. But you really want to tie it to their job, their job descriptions, what they're doing, and that it's consistent with how your business runs. If you do have medical information of your employees, you're limited in who you can disclose that to, right? So obviously something's happening in the workplace. If someone has a history of seizures, that, you've accommodated that, you understand where their prescriptions are. If they have a seizure in the workplace and you've got someone coming on site, first aid workers, you can disclose the medical history to those individuals in order for them to be able to treat the employee or provide for other procedures. You can disclose information requested maybe in an ADA accommodation to the employee supervisor. Again, if that disability requires some type of job modification or restricted duties in order to accommodate that individual. And then to the extent that you've got a government agency either investigating compliance with the ADA or even other federal agencies that are investigating a workplace incident and an accident, a workplace accident or illness or injury, those you are able to lawfully disclose that information to a government official. Oftentimes we might consider redacting information and or requiring that information is submitted confidentially and not subject to FOIA if it's requested by the government. But importantly, medical information, any information you gather from your employees, whether in an FMLA form, whether an ADA accommodation, whether it's a doctor's certification, anything that has medical information must be kept separate in its own confidential medical file, separate and apart from personnel records, only available in certain circumstances. So ensure that in your personnel records, you've always, like your I-9s, you always have a separate file for medical information with limited access. And then turning to kind of personnel files, right? So personnel files also contain private personal information about employees. It could have their social security numbers, it could have their address, it could have their date of birth, it could, include a lot of information that employees consider to be private. So those should also be maintained in a secure location, either in a physical locked file cabinet, or as we're seeing more often now, really password protected electronic files, and really should only be made available to individuals with the need to access. So that's generally going to be human resources. Other employees, certainly even other managers and supervisors, generally should not have access to employees' personnel records within the workplace. And while there's not any federal law that requires employees to have access to their personnel files, many states' laws do. And they have enacted various laws allowing employees and even former employees to ask for a copy of their personnel file. And I've listed the state laws here on the slide. Some states require that you respond in a certain time, which could be anywhere from a reasonable time to 7 days to 45 days. Most states specify a maximum number of times that an employee or former employee may access their personnel file, and some states limit which items an employee can access. And then recognize that if you don't comply within a certain number of days, as the statute requires, there may be statutory penalties that can be imposed. And I think California is one of them. We often see a former employee will request a copy of their personnel records under California state law. And that often is a trigger to us that this is an employee that may have an attorney or the attorney is asking, and that personnel file can then lead to maybe they thought they had a wage and hour claim, but then they look at a background check and they say, see, the background check didn't comply with the federal law. So be mindful when you do get a personnel record request of an employee, either from themselves after they've left the company or from an attorney. So with that, I'm going to turn it over to Darius, and he's going to talk about some location monitoring and other data privacy issues that you should be aware of.
Hi, everyone. So the next part we're going to talk about is employer monitoring using GPS. So like you all, I agree with the benefits of GPS, be it through Google Maps, be it through Find My iPhone. And there's obviously a lot of utility location monitoring, and that's why employers use it. And there's a few different ways that employers can kind of use it broadly. I'll probably go to the next slide. The main way that employers will sort of use location monitoring is to monitor employees' locations for, through a phone, for example. Sometimes you might get, download some application that indicates where the employer is, or through company vehicles, be it the car itself, their navigation system, or sometimes a GPS system might be located in the company car. And there's a variety of reasons why employers monitor employees. And they're important to kind of keep in mind because you really don't want to stray from them. So broadly, right, you want to, if monitoring employees' location assists in ensuring employees, safety and security, then that's a sensible decision. When it comes down to tracking the use of employer resources or increasing employee productivity, that's also essential. And the way that this can kind of look in the workplace, it tends to be sort of companies obviously that have mobile workforces, right? So if you can track where your employees are, you might be able to find out sort of if there's a delivery that the employer is being tasked with, where the delivery is, will it be on time? you can sort of locate where your company's main assets are at all times, be that for security, be that for sort of just tracking the use of your employer's resources. And as well as that, for companies where transportation is a central part of their business model, it enables them to sort of improve routing from where how sort of an asset might be traveling from one instance to the next, making sure that they get there in the fastest time. And then from sort of safety and security and kind of using or rather double checking whether employees are being productive, it also allows employers to kind of eliminate unauthorized vehicle usage. The employees might be using their company vehicles to run personal errands on company time. Employers are able to keep track of that and ensure that their sort of time isn't being wasted on employees running personal errands. So with that in mind, there's a few sort of obviously employees. There's many benefits to employers using location monitoring, but there are a lot of considerations that employers want to have in mind when they engage in location monitoring. So moving on to the next slide, one of the main sort of things that's changed recently is that for a while there weren't many state laws on this subject, and most recently California engaged in sort of or it enacted a GPS monitoring law. And as part of that law, employers can only sort of monitor employees when one, it's strictly necessary, and two, the employee is sort of apprised of it. If the law doesn't, if the employer doesn't have that, then they're going to run afoul of the law. In terms of sort of GPS surveillance broadly, there's a few considerations that employers want to have. And really, I think there's sort of two things you can narrow this down to. If the surveillance isn't necessary as part of a mobile workforce, right, that needs to be closely monitored, or it's being used to sort of minimize or eliminate safety risks to which the employer might not be the employer's workforce are routinely exposed. The key point being that the employers are routinely exposed to this. Then if you're outside of those two categories, then sort of GPS surveillance doesn't make quite as much sense, and it's not going to be as helpful to your workforce. And one of the main reasons it's not going to be helpful to the workforce is surveilling employees where their locations for no reason can have a pretty detrimental effect on employee morale. Employees who are subject to monitoring might feel that their employers don't trust them, and obviously if an employer is monitoring where an employee is and it's not for safety and it's not for sort of business reasons, then the employee might be right in that assessment. In terms of implementing a GPS surveillance program, that's probably the most important part for employers to get right, because it only happens once. So when an employer is sort of considering a GPS sort of surveillance policy, they think it might be useful to their workforce, it might be useful to their business model, there's a few things to really keep in mind. And that's one, that they communicate directly with the employees to the extent that their surveillance, that they explain, one, the purpose of their surveillance, why we're using this. This isn't for fun. Sorry, I'll try and speak a little bit louder. How the monitoring will be conducted specifically, when the monitoring will be conducted specifically, and as well as that sort of who will be privy to this data and the possible uses of such data. And all that really comes down to sort of creating like an appropriate policy that management can follow when using, when implementing GPS surveillance programs. Management wants to be able to communicate to employees through a policy that basically there's appropriate, proper uses that are written down for GPS surveillance data, and that the individuals who have access to that data are clearly sort of defined. And as well as that, when those individuals are using that data, there's policies relating to how the individuals use that data, and further, what misuse of that data could look like. Because employees are obviously want to be, if their GPS is being sort of tracked, it's important that employees are aware that the employer is taking care to only do it to the extent necessary. An interesting way, I'm moving on to the next slide, that GPS surveillance has also come up in a slightly different sector, but obviously related, is in regards to the National Labor Relations Board. In October of last year, the General Counsel issued a memorandum indicating basically a plan to sort of curtail workplace surveillance technologies at work. Present law under the NLRB already prohibits employers from using surveillance technologies to monitor or record union activity, through just basic recording. However, in this memorandum, which outlined a proposed framework that I'll explain next, the General Counsel had kind of expressed concerns over how electronic surveillance might prevent employees from sort of engaging in protected conversations relating to, one, just fundamentally unionization, but two, sort of terms and conditions of employment. And what she really focused on in that memorandum were GPS devices, keyloggers, monitoring software. The idea being that if the employer could tell where groups of employees were, that could sort of detract from their intent or ability to gather and discuss unionization or terms and conditions of their employment. So what this memorandum really outlined was a proposed framework, the key word being proposed. And that's that basically employers would presumptively violate the National Labor Relations Act, where their sort of surveillance and management practices viewed as a whole would tend to interfere with or prevent a reasonable employee from engaging in protected activities. Meaning that an employer who had some sort of all-encompassing surveillance policy that was discouraging to employees and sort of suggested that it was going to be difficult for them to meet without their employer knowing. In that instance, the presumption was that that would be a violation. And the employer response is that the employer would have to sort of establish, that the practice they're using are narrowly tailored to a legitimate business reason. And if there's no way sort of to avoid using these practices, then the employer would have to sort of disclose exactly the technology they're using, the reasons they're using it, and as well as that sort of how the information would be stored. The premise being, and the important part being, while, at present, this is obviously a proposed framework, it does sort of give you an eye into how GPS monitoring can sort of bleed into other areas of law, and how that's this promise of sort of surveillance and sort of using GPS monitoring just to kind of be aware of your employees is really affecting it, and sort of the NLRB has an eye to how that can affect employees' sort of ability to meet at work. So moving on to the next slide, what I wanted to do is sort of give an overview of a few. So we've explained sort of like the broad kind of areas of privacy, but sort of the state privacy laws that are currently enforced that employers might want to be aware of. The reason being that they typically for the United States in terms of privacy laws, it's really there's a patchwork approach in terms of how it's dealt with. Typically, states have laws that will protect specific information. And as sort of previously addressed, we've got kind of like HIPAA for specific health privacy issues, or Gramm-Leach-Bliley for specific financial privacy laws. And because of this is such a patchwork approach, there's sort of a little more, it's a little bit more burdensome on employers to keep apprised of what's going on. So what we're going to do in this next section is sort of explain a few different types of information and how, and different types of laws that are used in states to protect different types of sort of personal and sensitive information. So to start off with, like, biometric information is a really interesting topic, which if you're like me, obviously those kind of like the images of your sort of Mission Impossible retina scanner. And that is included in biometric information. But the interesting piece that I sort of really want to kind of stress is that biometric information is a lot broader than that. And I think because of that, and because it's such a new area of law and new area of technology, it's really important that employers are aware of it so they can sort of be conscious of where they might be storing or capturing biometric identifiers for their employees. So to start with, right, biometric in terms of the definition, really what it refers to sort of any sort of characteristics that can really uniquely identify an individual, typically from a biological and behavioral perspective, and sort of associated with technology where automated methods can recognize these sort of characteristics. Examples of these identifiers that are a little more straightforward are sort of facial recognition technology, sort of seeing the geometric figures that go over the face, sort of like in this picture, that can sort of really uniquely identify whose face is who. Iris recognition technology, or retinal scans. And interesting, the reason that sort of iris technology comes up so much is that an iris is actually unbelievably unique to individuals. I think it's actually sort of the most unique identifier on humans, and that like even twins have different irises. So if technology can pick it up, it's a great way to sort of uniquely identify a human and identify they're different from the next person. Similarly, fingerprints and palm prints have obviously been used for a long time as a way to identify individuals, as has audio recording, voice print matching, and genetic testing, to which is sort of a little bit less applicable to employers, because it just tends to be used less in an employer context, but is an important identifier to be aware of, that it does come under the definition of biometric identifiers. On the behavioral front, this is something I think that's interesting and sort of little bit less common. It'll be interesting to see how it can kind of come up into future privacy laws. Is that, gait analysis or computer keystroke patterns, those types of behavioral traits are included as biometric information. And as a result, if you want to keep an eye out for that, if any sort of technology you have might be sort of keeping track of not necessarily like the keys that are being logged, but specific like keystroke patterns. Moving on to the next slide, what I wanted to do was give a very brief summary of sort of the privacy laws that currently address biometric privacy. At present, there's really 3 laws that focus on biometrics specifically. That will change because biometrics is a relatively new phenomenon, and certainly it's a relatively new phenomenon in terms of the employer context. But what these laws have in common is that they govern the collection, use, disclosure, and destruction of biometric information. And they all sort of require one, notice to the individuals that biometric information is being stored, and as well as that written consent. There's the Illinois Biometric Information Privacy Act, BIPA, which I'll address in a little more detail next. The Texas Capture or Use of Biometric Identifier Act, and the Washington State Biometric Law. The distinction between these 3 is that for Texas and Washington, they are not enforceable through a private right of action, meaning that it would be an attorney general that would be the enforcement arm for these laws. However, in Illinois, that's not the case, and it's enforceable through a private right of action, meaning that groups of individuals, usually employees in this context, could get together and sort of sue an employee who has taken biometric information without their consent. And in Illinois, that's what's happened to really an extraordinary extent. So specifically under BIPA, what BIPA says is that employers sort of can't collect biometric information unless they sort of inform the subject in writing that they're doing so, inform them sort of the purpose, and that sort of there's a legitimate reason for why the information is being used, and as well as that engage in obtain the written release for the biometric information. Where this has really gone a little bit sort of like off the tracks in Illinois is that in terms of what a violation looks like, it can actually be each scan of biometric information. So a typical example is if an individual or an employer were to use a fingerprint scanner to kind of indicate when an employee is getting into work and when they're leaving. Each scan, if the employer had not provided that notice or obtained that consent, would be a violation of BIPA. So for an example, if let's say, by way of example, you had a 5-employee workforce, and each individual is coming in 5 days a week. They're going in, so they're 10 scans a week, right? 2 per day, 2 times 5 is 10. Then if you were to have sort of 5 employees, that's 50 scans, 50 violations in a week. If those 50 employees were to come to work for 48 weeks over the course of the year, that's about 2,100 violations right there. And in terms of penalties, it's $1,000 under BIPA for a standard sort of negligent penalty, and $5,000 for an intentional or reckless penalty. So if we were on the conservative approach and each of those penalties were just worth $1,000, suddenly over the course of a year, a 5-employee workforce has already violated BIPA 2,100 times. Or if you multiply those 2,100 times a $1,000 violation, suddenly that's already $2 million in penalties. And the key premise being here that these laws are new, they're important, and it's really important that employers are aware because the penalties can rack up quite quickly. And the reason being that biometric information, I explained earlier in IRIS, is as sensitive information as you can obtain for an employee. So I think that's really the reason that states protect it. And from an employer perspective, it's really important that employers are aware of what biometric information they're obtaining on employees, because it can absolutely backfire, and it's such sensitive information. Towards the bottom of the slide, outside of related to biometric privacy laws, there are sort of laws specific to fingerprints in and of themselves. California prohibits providing fingerprints to third parties when those fingerprints are taken as part of employment. And New York prohibits employers from fingerprinting applicants as a condition of employment, unless otherwise authorized. And that would usually happen in instances of for sort of like a medical sort of institution or an educational institution where other regulations prescribe that. Moving on to the next slide, another type of law that also sort of affects employee privacy are the state laws that kind of restrict employer use of sensitive personal identifiable information. And in this in this context, what that really means is social security numbers. So several states listed at the bottom sort of adopted these generally applicable statutes that really require employers to protect and limit their use of social security numbers. Obviously, with identity theft, social security numbers are ever so valuable to individuals and scammers alike, right? So it makes sense that employers would want to protect this information. And statutes that restrict social security numbers vary, or the use of social security numbers vary, but generally they provide that an employer can't publicly display or post the social security number of an employee. They can't print them on cards, and they can't sort of require individuals use them to access products or services. And they can't require that individuals sort of transmit the social security numbers over the internet without encryption, appropriate encryption, or use it to access the website without a password, identifier, or other authentication device. Point being, you can't have these laws are meant to sort of prevent employers from just using your social security number as your sort of employee number, your employee sort of ID. A lot of employers might use sort of the last 4 digits as an employee ID, and even those last 4 digits, because they're so specific, are also sort of covered in most of these laws. So you want to be careful about that as well. And then broadly, sort of in terms of, while these, and I would say in terms of protecting personal identifiable information, these sort of laws that focus on social security number are sort of the floor. There are states like, for example, New York, where personally identifiable information is a little bit broader, and that it can also include sort of employers not being able to ever post an employee's home address, personal phone number, and personal email address as well in public, because that likewise is personal information that state laws restrict the employer use of. Another type of laws that I want to move on to the next slide and discuss are state data breach notification laws. We've all probably heard about data breaches on the news, and I think what's interesting about it is, like, if you're like me, I tend to think of sort of your massive kind of commercial data breaches where lots and lots of information has been taken in one data breach. However, data breaches are it's a more broad term than that. In terms of the definition, it's the unlawful and unauthorized acquisition of personal information that compromises the security, confidentiality, or integrity of that personal information. All 50 states and DC have adopted these kinds of law, but the threshold for the number of employees where the data breach notification law might be triggered varies a lot by state. I mean, for DC example, it's 50 residents, some are 500, some are 250. So it's really important to check what state you're in. And then sort of understand sort of what personal information can be, because again, that varies by state. Typically, it's going to be sort of what makes sense, right? It's going to be anything that sort of prescribes sort of an individual first name and last name, and also connects it with social security number, driver's license or state identification card number, financial account, credit cards, debit card numbers, obviously. Anything sort of like anything that will sort of provide some jeopardy to that individual's identity over the internet. The obligations vary among the states specifically, but there's really 4 categories that you want to be aware of. Specific, what agency must be contacted. If you become aware of data breach, in all 50 states, you're going to have to reach out to an agency if you meet the affected individual threshold. Sort of how long before the notice must be provided. Those vary. Sometimes they can be 72 hours, and then it can be as soon as possible. But it's important to be aware of those before the fact so that you're not sort of caught cold in the event of a data breach. And then as well as that, each state also has sort of different sort of requirements in terms of what state agency notice should look like. They'll sort of indicate what should be, what sort of information should be disclosed to the state, and as well as that, what sort of notice should provide to the individuals whose information has been taken. Typically, those sort of notifications will include, what happened, what breach was, what information they think was taken, how did they find out that the information was taken, what has been done since, and as well as that, sort of how many employees have been affected. And usually states will want to see a copy of the notice that was provided to employees. Moving on to the next slide. What I wanted to do is just give a broad sort of overview over this, like the status of comprehensive state privacy laws across the country, not necessarily limited to employee privacy, but sort of explain it as a backdrop, as I'll explain more how employee privacy might feed into these laws in the future. So at present, there are really 5 main comprehensive state privacy laws: California, Virginia, Connecticut, Utah, Colorado, and they'll all be effective by the end of this year. Usually these laws, they really focus on sort of regulating companies that profit from data, the companies that can sort of use, share, or sell data that they collect from consumers. And what these laws do is they prescribe, whether consumers must opt in or whether the companies must give consumers the ability to opt out of the information being taken. And as well as that, and relevant to what I'll explain later, they give consumers sort of a bill of rights indicating sort of what rights they have over this data. And typically what those rights look like: the ability for the consumer to know what information a specific business has taken from them, the ability to sort of access that information from the business, the ability to have data portability, which means that if a company has taken an individual's information under most of these laws, individuals will now have the ability to sort of take that information and say, well, actually, I'd like to take it back and give it to a different company or use it elsewhere. Individuals also have the opportunity and right now to sort of delete information that companies take, and they have the ability to correct information that a company has taken from them. Individuals can also opt out from companies in regard to if they're going to try and sell that data, the individual can say, no, you cannot sell that data, I want to opt out of that. And they can also opt out of selective advertisements being sort of targeted at them in the future. Of these states, what's interesting is that California is sort of the first US state to really engage in the privacy law front in terms of consumer privacy laws. And a lot of that is because obviously out in California, it's a bigger state, and there's a lot of sort of companies that are sort of profiting from taking data from consumers. But it also became the first state to really extend consumer-like privacy rights to California residents in their roles as job applicants, employees, and independent contractors. So while Virginia, Colorado, Utah, and Connecticut have, also adopted really comprehensive data privacy laws, they haven't extended the laws in the employment context. And although there's, several, federal data privacy bills pending, whether those bills will apply sort of in the workplace context remains to be seen. I mean, notably sort of the laws that are effective in 2024, 2025, and 2026, all of those are also limited to consumer data, but it will be interesting to see if that changes, if any of these laws, depending on how California sort of enforcement goes, whether they'll also sort of employ an employee right, and whether employees will have rights to the data that the employer holds concerning them. Moving over to the next slide, what I want to speak about a little bit is the California Privacy Rights Act. So as I mentioned, California was the first state to go down this consumer privacy law lane, and it started in 2018 with a law called the CCPA, the California Consumer Privacy Act. That happened. That was only related to consumer privacy data, but in 2020, that was amended with the California Privacy Rights Act, and that no longer accepted employers from having to protect the information, or from creating rights for their employees. And what it specifically did was create 3 new obligations for employers that they needed to be aware of in regard to their employees' data. So first, employers had to sort of provide notice of collection, indicating that when employers must provide employees and job applicants notices of collection concerning how the employer handles private employee data, a notice of their rights under the CPRA, which I'll explain next, and a means of how to ask about how to exercise those rights. And as well as that, the employers need to include specific CPRA provisions in contracts with vendors that handle private employee data, meaning that if a California employer is using some other third party to the standard example would be sort of keep track of the employee's time, like a time clock vendor. They have to include in that contract that sort of third party can't use or sell that data for profit, and that the data can't be sold on down the pipeline. And then finally, the part that I think is really important to be aware of, and really to see how it sort of happens in practice, is that the CPRA also sort of affords employee privacy rights to the employees. It means that the employees have the right to, 1, access the personal information that the employer holds about them, 2, correct that data, 3, potentially delete that data. 4, opt out of the sale or sort of sharing of that personal data to the extent that applies, as well as that the employee will still have sort of that data portability right, meaning they can sort of collect that data and move it elsewhere. They can limit the employer's use of sensitive personal information, and the employer will have the right to be sort of protected from retaliation for exercising their privacy rights. This law has recently come into play, so it'll be interesting to see how it comes in, how it's actually enforced. But because it grants this sort of a wide variety of rights to employees, it's an important one to be aware of to see how employers in California will respond to it, and similarly how employees will respond to it, whether employees are trying to use or potentially abuse their CPRA rights to kind of get copies of personal information held by the employer, or if someone is able to use effectively a retaliation claim against their employer for exercising their privacy rights. But now that I've sort of warned you off and alarmed you about the CPRA, it's also important to understand sort of when it applies. And what's interesting about the CPRA is typically for the consumer privacy laws, an employer would sort of have to meet a revenue threshold, as well as a threshold indicating the percentage of annual revenues they're obtaining from selling consumers' personal information. But in this instance, employers have to comply with the CPRA if they satisfy any of these criteria, meaning if they have annual gross revenues in excess of 25 million, or they derive at least half of their annual revenues from selling consumer personal information, or they handle, buy, share, or sell personal information belonging to at least 100,000 California residents annually. So it's broad. It can apply to a little bit more than the standard comprehensive consumer privacy laws. So it's an interesting one to keep an eye on and see how sort of enforcement and how California residents use it. So to close off, I wanted to just sort of explain a few things. I thought a good way to end this was a few considerations that we thought to keep in mind broadly. So one, I think most of how we've discussed in this presentation is sort of how employee privacy sort of issues can come up specifically related to employee privacy, but I also want to explain how those might bleed over to the employment discrimination wage hour context. In the employment discrimination context, typically, be it a discrimination claim, be it a retaliation claim, they're all sort of underpinned by this general awareness, well, specific awareness by the employer of a protected class or a complaint. Workplace monitoring just makes it a little bit easier for employees to find ammunition wherein the employer might have had awareness of the protected class or complaint. So it's really important that employers who use any sort of employer monitoring technology have policies in place indicating, one, how they're using these technologies, for what purposes, and exactly who has access to them, so that they can sort of cut off any sort of awareness of protected classes or harassment complaints if they were to arise. Similarly, on the wage and hour front, failing accounts for all employee time can also result in unpaid wages claims. Unpaid wages claims, and how that usually comes up is, some workplace monitoring technology might not be able to account for all an employee's time if the employer hasn't considered it beforehand. Meaning that if an employee is spending time working away from the computer, the employer is only monitoring the employee's time and only paying them for the time they're at the computer, the employee might end up working more than a 40-hour work week, and the employee could be entitled to overtime pay. An example would be sort of in 2021, a former employee sued for unpaid wages after the former employer required her to install an employee monitoring software that audited her keystrokes and presence on the company's webcam. The employer hadn't compensated the employee for any 10-minute time frame when the employee was doing work outside of their actual keyboard or outside of that camera, and as a result, the employer was liable to the employee for that lost time. Moving on, I think the last thing I wanted to explain was sort of bring your own device policies, which are common in something that broadly, or if you bring your own device policies, allowing employees to use their own mobile devices for work are broadly really helpful. They enhance productivity and they decrease IT costs, but they also lead to sort of legal and other risks that you want to be aware of, including just on the basic level, the increased probability of data breaches. I mean, most employers that have used BYOD programs have some sort of risk or have experienced a data breach resulting from employee error or intentional wrongdoing. So it's really important that you have a written BYOD policy, meaning that it's not boilerplate and it's customized to your specific workplace. So you want to address sort of trade secret protection, access to sort of specific association emails, what to happen in a data breach, as well as having employee training initiatives. So the use of kind of a single mobile phone for work and personal purposes can also kind of present complications when an association wants to monitor activities of an employee for security or investigative reasons, because suddenly the employee's personal information is also being contained within this phone and might unintentionally end up within the scope of a workplace investigation. So again, it's really important that BYOD policies, really express for what purposes, the devices will be accessed by the employer, and for what purposes they won't be accessed. Finally, we just wanted to end with, four really broad sort of takeaways to explain what employers should consider moving forward in regard to employee privacy and how to comply with sort of this sort of wide range and patchwork of laws. The basic, I think, most important rule to be aware of, sort of review the software you're using and verify what information you're reviewing and storing. You want to be aware of sort of what your software is catching, what it isn't catching, so that down the pipeline, one, you don't run the risk of some wage and hour complaint because you're relying on a software that wasn't, adequately accounting for all an employee's time. And similarly, in the biometric privacy law, you want to make sure that you're not accidentally or unintentionally obtaining biometric information or using biometric information or storing biometric information from an employee without their notice and consent. It's also important, because these laws are changing so regularly, to review employee handbooks and privacy policies regularly to determine whether they require updates, be it in a change of the technology you're using it, be it in a change of the law, and also sort of map the jurisdictions where you're working in so you can have an idea of your privacy obligations based on those states. And again, to reiterate, it's always important to review these changes to the privacy laws because they are coming up quite quickly, and they'll change as technology sort of accelerates, and as technology becomes more useful and helpful to employers. So with that, I think it's a good place to end. I hope this was helpful. Thanks so much for your time. I really appreciate it.
Thanks, Darius. Here is our upcoming webinar series for the rest of the calendar year. So we've got one on ADA reasonable accommodations next month. We hope you can join us, and we'll be talking about artificial intelligence in November and an NLRB update in December. Make sure you check out our blogs, the OSHA Defense Report blog, the Employer Defense Report blog, Cal OSHA and MSHA Defense Report. We update those regularly, weekly, and so it's a great spot for some timely information about what's happening and best practices that you can implement in your workplace. In the meantime, thanks so much for everybody for participating in today's webinar.